Imagine you hire a company to do a job, but it does the first part so poorly that you're concerned whether it can handle the second part. You demand some assurance that it can, but the company refuses to discuss the matter until you pay the balance for Part 1. What are your options? That was the situation a company faced in Lane Enterprises versus L.B. Foster. L.B. Foster Company, which we'll call Foster, manufactured steel bridge components. It contracted to sell components to Hammond Construction to build a bridge in Ohio. The components were to be coated in accordance with state specifications and supplied in 2 stages. Foster subcontracted with Lane Enterprises to coat the components. Lane coated the Stage 1 components, but some contamination was trapped under the coating. The state inspector rejected the components, but allowed them to be remedied by making field repairs. Lane indicated that it likely wouldn't be able to satisfy the state specifications for the Stage 2 components. Foster owed Lane around $18,000 on a $134,000 contract. Foster refused to pay Lane the balance until the field repairs were made. Foster and Lane agreed to have another company perform the field repairs for around $11,000, to be deducted from what Foster owed Lane, leaving a balance of $7,000. Foster then told Lane that it wouldn't pay the remaining $7,000 until Lane gave assurances that it could coat the Stage 2 components to specification. Lane refused to discuss Stage 2 until Foster paid the $7,000. Foster hired another company to coat the Stage 2 components for around $42,000 more than it would have paid Lane. Foster sued Lane for $42,000. Lane counterclaimed for the $7,000 Foster still owed for the Stage 1 work. The trial court found that Foster had breached the contract and awarded Lane $7,000. Foster appealed to the Superior Court of Pennsylvania.